So
We're all about looking forward today.
we are looking forward and planning, which is part of what I do with my clients. And it's really about finding out, everyone knows about a will. Most people get a will when they get married.
Sometimes not till they're 90.
And, okay. And then, so I just want to sort of flush out a few of those points with you. So it's not only a will, but an enduring power of attorney and an advance care directive.
That's right. So the latter two documents that you just mentioned there are like living wills. So they are in place while you are alive. But if something were to happen to you and you were in an accident or in hospital, unconscious or unable to make your decisions about your finances and your medical affairs, then you have somebody in control to make those decisions for you. And it's really important that you get those documents in place while you can.
Well, you got your noodles?
That's right. Otherwise, you might not get the say as to who you want to be in control of those things for you.
So what if they don't? What happens?
We end up before SACAT, which is the South Australian Civil Administrative Tribunal.
Oh,
yeah.
Yes.
And they'll have a hearing and they'll determine who the best person or people are
Yes.
to make those decisions. Particularly if there are conflicts within families, we tend to see...
Or blended families.
We end up before SACAT. And the guardian of last resort, so if the tribunal member can't make a decision as to which family member should be in control of someone's medical affairs, the public advocate would be appointed.
Oh.
And in relation to someone's finances, it would be public trustee.
I was just going to say, a lot of people know and aware of the public trustee, and I've dealt with the public trustee on a number of occasions. Very slow and very encumbersome, and
very
quite expensive,
bureaucratic.
and very quite expensive as well. A lot of people think that it's not, but I think 2% they take of the assets.
Trap for young players is they get a will done for free.
Yes.
And then when somebody passes away, they take a percentage of the deceased's estate.
Correct.
Plus they charge for all of their administration as well.
Correct. So a big trap for young players and people who think that they're going to get out of it cheap by not having to pay for a will. Like, you pay peanuts, you'll get monkeys. So we don't want to do that. So what would you advocate people, what age would you say for people to get a will?
Everyone should have a will once they turn 18.
18? Fantastic.
Particularly if you're working. I always speak to the kids that are working at the checkout at Woolies and they ask me, what do you do? And I say, I do wills and estates. And then I say, do you have a will? Oh, no, I've got nothing to leave but my HECS debt. And I say, but you're working for Woolies. And they pay you. They pay you superannuation. And there's a fair chance that at your age, there's a fair chunk of coin attached in life insurance, attached to that super product.
Correct.
So if you don't have a will, you won't have a say in where it goes.
No.
And it will all be determined by legislation.
Correct. And then you'll leave a mess for your loved ones
to sort out.
Correct, which happens a lot. Do you see that a lot?
I see it a lot, particularly just thinking about superannuation and life insurance. I had a very young boy who committed suicide, and he had about $600,000 in life insurance attached to his superannuation policy.
Oh my gosh.
And it was under intestacy, all going to pass to mum because dad had passed away. So it was all going to go to mum, and mum really didn't want it. She wanted to set her other children up with the benefits of the policies. So that took about 2 years to sort out, but it was a complete pain. And
Absolutely.
like I said, just getting yourself prepared makes gives you peace of mind.
Correct.
And leaves your loved ones without that mess and heartache to sort out in the situation where they're grieving and dealing with your loss or incapacity. Right. And all of a sudden.
Yep. And not a lot of people are good with paperwork.
No, they're not.
And facts and figures and dealing with processes. So, it's a unique person that does all of that. So what about those that try and do a do-it-yourself will, go to the newsagent and...
It's better than nothing.
True.
Better than nothing. But one size does not fit all. They are very, very generic. All of the what-ifs, and that doesn't account for that. It doesn't really provide for blended families. It doesn't provide for a lot of different
entities, like
trusts,
the
family
trusts,
trusts.
self-managed super funds, you name it.
They also don't necessarily tell everybody that you have to sign with the same pen.
Of course. Now, that is an interesting point because in our firm, I tell everyone when they've got a photocopy of will, do not unstaple.
Don't take it apart.
Don't take it apart because as soon as you do that.
Don't attach anything to it with a clip or paper clip.
Correct.
And the third thing that goes with that is make sure your executor knows where your original will is.
Yes.
And if it's in a safe and it's got a passcode or something, they need to know how to crack it open.
That's it. Yes. Otherwise, you might be getting Dodgy Brothers Incorporated into crack the safe. Goodness me. What about incorrect titling of assets?
So a lot of people don't understand that when you have a house, for example, with a spouse, you can hold the property as either a joint tenant or as tenants in common.
Yes.
If you hold it as a joint tenant, then on the death of one party, the whole property passes to the survivor. If you hold it as a tenant in common, then there's effectively half a house to fall into each person's respective estates.
Yes.
Quite often I get, I want to leave my half of the house to my children and Tom over here wants to leave his half of the house to his children. Well, you can't do that if there's a joint asset because it will all automatically pass to the survivor. So that's one thing to consider, particularly for blended families, wanting to protect each other's children from potential
inheritances. Because if the person who passes away, it automatically goes to the other person. That person that passed away, their children could actually be eliminated from all estate
they could be
benefits.
However, there's changes to the wills and succession law in South Australia coming into effect from the 1st of January next year.
Oh, well, that's good to know.
Yes. And one of the things that it does is, like today, that disinherited child would be unable to claim against a step-parent. But the new legislation is opening the path for that sort of cross.
Yes.
But we don't know the exact circumstances as to how that's going to play out until we see the cases work through their way through the system.
So let's not rely on anything.
Oh, no, it's better to be safe than sorry.
And of course, getting advice about all of that is paramount.
And there's things that people can do. If you do hold the property as a joint tenant, you can sever the tenancy so that there is a half to deal with in each person's estate, and you can leave the survivor the right to stay on in that property for
life
as long
interest,
as they need. A life interest for as long as they needed to, so that you're not effectively kicking them out on the streets.
Which is not what is intended. No one wants that to happen, do they? Right. There's some people that like having testamentary trusts in their wills. Do you want to explain what that all means?
So a testamentary trust is a trust that is like a family trust, but it lies dormant within your will and comes into effect on your death. And it means that the inheritance can move into the trust and provide tax advantages for a beneficiary going forward. So I'm worth more dead than I am alive. So
Me too.
So I have a testamentary trust in my will for my son, and it just means that if he was married, for instance, and they had a baby, he could distribute income generated by the trust to that young child without having to pay the adult tax on that distribution.
Yeah, so I know the taxation, and we won't get into too much of that because it is quite convoluted, so you really need to get advice around that, but it is a tax haven, if you like, for each beneficiary. So, yes, and I like it so much as that, and I believe that assets in the testamentary trust don't get brought into family court, or do they now?
If
in a divorce,
yes. So it is a protection.
Yeah, it is
element,
a protection.
But
it's not one you want to hang your coat on.
Exactly, but it does help a little bit.
It does help because it is part of the inheritance, and inheritance generally are excluded from assets. But again, it really depends on circumstances around that, and so don't hang your hat on that, for example. So, yeah, anyway.